a section-by-section walkthrough of California Form FL-180, the judgment that formally ends a marriage or domestic partnership, including the required attachments, the mandatory waiting period, and common mistakes to avoid. What is Form FL-180? Form FL-180 is the California Judicial Council form titled Judgment. It is not a request, like the petition, FL-100, or response, FL-120. It is the document a judge reviews and signs to officially resolve the case. Once signed, FL-180 becomes the court's final word on your case. It identifies the parties and case number, states which outcome the court is granting, sets the date your marital status changes, and attaches or incorporates the terms that actually resolve property, support, and custody. Everything that came before it, the petition, the response, disclosures, and any settlement agreement, exists to build toward this one form. Types of judgment: dissolution, legal separation, or nullity. FL-180 covers the same three outcomes available on the original petition: dissolution, ending the marriage or domestic partnership entirely; legal separation, resolving property, support, and custody without ending the marital status; nullity, a court finding that the marriage or partnership was never legally valid. The type of judgment entered on FL-180 has to match what was actually requested and litigated in the case. A judge will not sign a dissolution judgment if the petition only asked for legal separation, for example, so this section simply confirms the outcome the case has already been built around. Section-by-section walkthrough of FL-180. Here is what the form actually asks for. Case and party information. At the top, you'll enter the county, case number, and the full legal names of the petitioner and respondent, exactly as they appear on the rest of your case file. Consistency with your petition and response matters here more than almost anywhere else in the process. Type of judgment. You'll check the box for dissolution, legal separation, or nullity, matching the outcome your case has actually reached. Judgment date and effective date. This section states the date the judge signs the judgment and, separately, the date your marital status actually changes. These are often different dates, and the difference matters for benefits, taxes, and remarriage. Attachments and incorporated agreements. FL-180 references and attaches the documents that resolve the substance of your case, most commonly a marital settlement agreement. Instead of retyping every term, the judgment simply incorporates the attached agreement by reference, so the judgment and the agreement have to be entirely consistent with each other. Other orders. If your case involves custody, visitation, or child support, those orders are attached as well, generally on their own judicial council forms rather than rewritten inside FL-180 itself. Every term in FL-180 and its attachments has to match your underlying marital settlement agreement exactly. A judgment that conflicts with the signed agreement is a common reason courts reject a submission and send it back for correction. The date your marriage ends and the waiting period. One of the most important entries on FL-180 is the effective date, the date your marital status actually changes from married to single, or for a domestic partnership, the date it legally ends. California requires a mandatory 6-month waiting period before a marriage or partnership can end, measured from the date the respondent was served. Practically, this means the effective date on FL-180 cannot be earlier than 6 months and 1 day after service. The judge can sign the judgment itself before that date arrives, but the actual change in marital status cannot take effect any sooner. This waiting period applies no matter how quickly both spouses agree on every term, and it cannot be waived by mutual consent. Attachments to FL-180. What gets attached to FL-180 depends on what your case actually resolves, but the following are common: marital settlement agreement, FL-341, custody and visitation order, FL-342, child support order, and other property or support orders. Missing or inconsistent attachments are one of the most common reasons a judgment is not signed on the first submission. FL-190, Notice of Entry of Judgment. Form FL-190, Notice of Entry of Judgment, is filed together with FL-180. Once the court clerk enters the signed judgment into the court's records, the clerk uses FL-190 to formally notify both parties that entry has occurred. The clerk mails a filed copy of FL-190 to both the petitioner and the respondent. This notice matters beyond formality. It documents the exact date the judgment was entered, which can be relevant for deadlines tied to appeals, remarriage, and other post-judgment steps. Common mistakes to avoid: listing an effective date earlier than the 6-month and 1-day waiting period allows, submitting FL-180 without the required attachments, such as the marital settlement agreement, FL-341 or FL-342, terms in the judgment that do not match the signed settlement agreement word for word, inconsistent names, case numbers, or dates compared with the petition and response, forgetting to submit Form FL-190 along with FL-180, requesting an outcome, dissolution, legal separation, or nullity that does not match what was actually requested earlier in the case. What happens after judgment? Once FL-180 is signed and entered, a few things typically follow. The court clerk enters the judgment into the official case record. The clerk mails FL-190 to both parties as notice of entry. Your marital status changes on the effective date stated in the judgment, not necessarily the signing date. You may want to request certified copies of the judgment for name changes, benefits, or other post-judgment needs. If you're still early in the process and weighing whether to prepare your own paperwork through to judgment, our guide on how to file for divorce in California without a lawyer walks through the full self-represented path that leads up to this final form. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-180 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.